Mr. Cooper, seconded by Mr. Rankin, moves that Bill C-417, an act to amend the Criminal Code, disclosure of information by jurors, be now read a second time and referred to the Standing Committee on Justice. Debate, the Honourable Member for St. Albert, Edmonton.
Thank you, Mr. Speaker. It is an honour to rise to speak on my private member's bill, Bill C-417. Bill C-417 seeks to amend Section 649 of the Criminal Code, which is the jury secrecy rule. The jury secrecy rule prohibits a juror from talking about their experiences during jury deliberations for life. My bill would carve out a minor exception to the jury secrecy rule to better help jurors who are suffering from mental health challenges arising from their jury service get the help that they need. Before I discuss the particulars of the exception proposed in my bill, I think it would be helpful to provide some context and some background to how I arrived at introducing this bill. This bill arises from a study of the Justice Committee, of which I'm a member, on juror supports. Indeed, it is the first parliamentary study on juror supports, and in that regard, I would like to commend the member for Cowichan, Malahat, Langford for his leadership in taking the initiative to bring about this study. It proved to be a valuable study that resulted in a unanimous committee report with what I believe are many important recommendations. Mr. Speaker, during the study, we heard from many former jurors who went through difficult trials and who were exposed to horrific evidence. We heard about the stress and anxiety that it caused them. We heard about how it impacted their relationships with others, including friends and family. We heard about the challenges that they faced upon trying to return to work, upon trying to return to the life that they knew prior to jury service. And yes, Mr. Speaker, we heard about the stress and anxiety and even PTSD that they have suffered as a result of their jury service. The testimony of these former jurors was extremely powerful, and I would like to read into the record some of the testimony of the former jurors. Mark Ferrand, who served as a jury foreman in a particularly gruesome murder trial, said this of his experience, quote, "Images would haunt me day after day, an unrelenting bombardment of horror. My daughter's red finger painting would hurtle me back to the scene of the crime, and I would stare transfixed, seemingly out of space and time. Sometimes I would just start to cry for no reason at all. Intimacy with my spouse was impossible, and I found myself either sleeping downstairs on some kind of vigil or sleeping in my children's rooms at the foot of their doors, if I even slept at all. I began to see everything as a potential threat, and even began arming myself with knives, just in case. I would say to myself, as I would take my children to the park to play, my daughter asked me one day why I was putting a knife in my jacket, and I struggled to understand, even myself, why I was doing it, let alone to explain it to a 3-year-old girl. I knew something was horribly wrong with me," unquote. And indeed, something was horribly wrong because Mark Ferrand was diagnosed with PTSD as a result of his jury service. Tina Danzer, who more than 2 decades ago served on the Paul Bernardo jury, said this, quote, "At that moment, I had no way to fully comprehend how bad it would be. Imagine watching young girls being raped and tortured over and over again. You couldn't close your eyes and you couldn't look away because your duty was to watch the evidence. Many days I would go home in a fog, as if heavily medicated. I counted on my husband to care for our children and to assume most household responsibilities, as I often had difficulty focusing on tasks after a day in court. Most nights the videos would play in my head over and over again. I had difficulty sleeping. Intimacy with my husband became non-existent for a long time. Even after the trial ended, I became afraid to go outside after dark, and to this day that still affects me. I have extreme distrust of strangers." And then there's Scott Blue, who sat on a jury in a murder trial that involved the murder of a 2.5-year-old boy. He said this, quote, "To this day, I worry all the time that something will happen to my kids, that someone in their life will hurt them the way the victim was hurt. I'm super vigilant and accused of being way too overprotective, but not knowing what I know, I cannot be too careful with who looks after my kids." And that's just a part of what was a lot of testimony, very powerful testimony of jurors who quite courageously shared their stories, shared their experiences, shared about how their jury service changed their lives forever. We heard at the Justice Committee that one of the biggest impediments for jurors to get the help that they need is the jury secrecy rule. The jury deliberation process is, in fact, one of the most stressful aspects of jury service. After all, it is a time when jurors are sequestered with 11 other strangers, sometimes for hours, sometimes for days, sometimes for weeks, where they have to go through methodically the evidence, sometimes very disturbing and gruesome evidence. And they ultimately, Mr. Speaker, have to decide the fate of an individual. In the most serious of cases, that fate may be to put someone away for the rest of his or her life. And in that regard, Tina Danzer, who served on the Bernardo jury, described this of the jury deliberation process. Quote, "After the Bernardo trial ended, I was only sequestered for one evening, and basically I got the question, what took you so long? You can't answer that. You can't discuss what the other people in the room would like to do or not like to do. Again, you've seen the evidence, and you've decided that the person is guilty, but you are still sending that person to federal prison for the rest of their life. You shouldn't feel guilty, but somehow deep down you still do. Talking through those things could be quite helpful." Dr. Sonia Chopra, who is a psychologist who appeared before the Justice Committee and has undertaken a fairly extensive study around former jurors, identified as a result of her interviewing many former jurors that 7 out of the top 10 stressors for jurors occurs at the time of the verdict and the jury deliberation process leading up to that. In her study, some of the comments of jurors about the deliberation process include, quote, "The deliberation room, that's where the stress began. The trial was fun." Another juror said, "I was appalled with the jury. If there's a weak link, that's where it was." Another said, "Stress wasn't because of the trial, it was because of the other jurors." Another, "Infighting with the jury was my only source of stress." Another former juror said, "Deliberations were stressful for me, and I'd been holding it in, and another said after the verdict, I was crying. Mr. Speaker, taken together, it is clear that not being able to talk about those experiences, in fact, for it to be a criminal code offense to talk about those experiences to a mental health professional, is a serious impediment towards jurors getting the help that they need. And so, Mr. Speaker, that's where this bill comes in. It seeks to make a minor exception to the jury secrecy rule, namely that a juror, in the course of getting mental health treatment arising from their jury service, could share their experiences with a mental health professional who is bound to confidentiality post-trial. This is consistent with an important recommendation of our unanimous report. And I want to stress, Mr. Speaker, that this minor carve-out is in no way inconsistent with the rationale underlying the jury secrecy rule, including ensuring the finality of a verdict and protecting the sanctity of the jury deliberation process, because again, this exception would only apply post-trial to a mental health professional who is bound by confidentiality. It therefore, Mr. Speaker, may come as no surprise that at the committee this received very widespread support from the witnesses, including from former jurors, from mental health professionals, from lawyers, including William Trudell, the president of the Canadian Council of Defence Lawyers. This is a non-partisan issue. It is a common sense issue. It's about doing the right thing to help jurors get the help that they need by making a minor amendment to the criminal code. And, Mr. Speaker, in the non-partisan spirit of this bill, I'm honored that the member for Victoria, the NDP justice critic who I have the honour to serve on the Justice Committee with, is the seconder of my bill. I'm very pleased that the chair of the Justice Committee, the member for Mount Royal, who ably serves as the chair of the Justice Committee and played an important role in the study as chair, is supportive. I see my friend, the member for Oakville North Burlington, who is a co-seconder, and other MPs on all sides of the House. And I'm also very honored that Mark Ferrand, who is one of the leading advocates in Canada for juror supports, stood with me here in Ottawa when I announced this bill. Mark Ferrand often says that jury service is the last mandatory form of service since the abolition of military conscription. And in that regard, I say it is completely unacceptable that jurors are unable to get the help that they need for doing nothing more than their civic duty. That, Mr. Speaker, needs to change. Bill C-417 helps change that, and I urge, on that basis, the speedy passage of this bill. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you. And I appreciate the contributions of the member from St. Albert, Edmonton at the committee, but also today in this House in terms of presenting this private member's bill. I wanted to ask him, because it's prior to my tenure as Parliamentary Secretary, but in terms of those committee deliberations, if you could advise this House about some of the practices that are taking place in different provinces around the country. I know some of them have put in place supports, counselling, psychological supports for jurors, and also in the course of applying those supports and that treatment, whether the issue of Section 649 of the code has ever actually resulted in prosecutions of jurors in different parts of the country as a result of some of the treatment that they've received.
The honourable member for St. Albert Edmonton.
Well, thank you, Mr. Speaker, and I want to thank the Parliamentary Secretary to the Minister of Justice for his question and also for his work on as a member of the Justice Committee and in his capacity as Parliamentary Secretary. The honourable member raises the issue of juror supports across Canada. What I can say is that there is a patchwork from province to province, with some provinces having better juror supports, some having less, and some having none at all. And it is why it was a key recommendation of our committee to call on the federal minister to work with her provincial and territorial counterparts to see that a better consistency of supports across Canada, and also to provide one-time funding to help make those supports available and accessible right across Canada.
Questions and comments. The honourable member for Oakville North Burlington.
Mr. Speaker, and I first want to thank the honourable member for bringing forward this bill. I'm wondering if he could share with the House other jurisdictions who have brought in this type of legislation and the impact that that legislation may have had on drafting his private member's bill.
The honourable member for St. Albert Edmonton.
I thank my friend for Oakville North Burlington, and again thank her for her support of this bill. There is similar legislation in place in the state of Victoria in Australia. And the evidence before the Justice Committee was that since that law was passed, that it has worked quite well. There were no issues that arose from it. And that makes sense because, again, we're talking about post-trial, totally confidential in the context of meeting with a mental health professional.
Questions and comments. The honourable member for Carleton.
Yes, I'd like to thank the honourable member for introducing this bill and for serving this House with his encyclopedic knowledge of statutory law and of our legal system. We're all well served by his presence here. The member spoke very eloquently about the importance of providing mental health support to people who go through the traumatizing process of serving as jury members during trials on allegations of violent crime. Can he also discuss how the existence of such mental health supports may actually lead to higher quality deliberations? Will members of a jury, for example, be able to deliberate more freely and more confidently, knowing that they will have support in the aftermath than they are capable of doing right now? Thank you.
Member for St. Albert Edmonton.
Well, I thank the member for Carleton for his kind words, and he raises a very important point, and it was one that was raised by a number of former jurors and others who appeared before the committee, that by knowing that following the conclusion of a trial, one can go to a mental health professional and talk about all aspects of their jury service, that would go a long way to comforting jurors. And it would also encourage Canadians to step up to the plate, because far too often people who are called to serve on juries often do not want to go on to juries, and part of the reason is because of the very difficult circumstances that former jurors can find themselves in post-trial. So this is an important step in that regard.
We go to resuming debate. The Honourable Government House Leader is rising on a point of order.
Thank you, Mr. Speaker. There have been discussions amongst the parties, and if you seek it, I think you'll find unanimous consent for the following motion: that notwithstanding any standing order or usual practice of the House, A, any recorded division requested in relation to the third reading stage of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts, or the third reading stage of Bill C-86, a second act to implement certain provisions of the budget tabled in Parliament on February 27, 2018, and other measures be deferred until Monday, December 3rd, 2018, at the ordinary hour of daily adjournment. and B, at the expiry of the time provided for oral questions on Thursday, November 29, 2018, the House revert back to the rubric motions for the purpose of considering a motion to concur in the 66th report of the Standing Order Committee on Procedure and House Affairs.
Does the Honourable Government House Leader have the unanimous consent of the House to propose this motion? No? Right, there is no consent. Resuming debate, the Honourable Member for Mount Royal.
Thank you very much, Mr. Speaker, and it's a pleasure to rise. I want to thank my colleague from St. Albert, Edmonton, for the private member's bill that he put before us. It is consistent with the report from the Standing Committee of Justice, which had a unanimous approval. And I also want to salute my colleague from Cowichan, Malahat Langford, who, along with the member for Victoria and the member for Niagara Falls and all of the other members of our committee, have worked so diligently in terms of bringing this issue to the fore. Jurors throughout Canada have a serious issue. As the member for St. Albert Edmonton reminded us when he quoted Mark Ferrant, jury service is essentially the only compulsory service left in this country. And it is the only time that members of the public often find themselves in contact with the justice system. So while this bill, which I will get to, is a very important component, the study that we did showed many, many flaws in the way we treat jurors in Canada. For example, it showed us that in some provinces, the rate that we pay a juror has not been increased since the early 1970s. And that there is a great divergence amongst provinces, with some provinces paying up to $163 a day and other provinces paying nothing for the first few days of jury services, leading to many people being unable to afford to be on a jury. And when we want juries, we want them to be representative of the public at large, not simply one small group that it can afford to do jury service. We found that in some provinces, there was excellent services provided post-trial to jurors, only in recent years, but some provinces have started real legal support programs. Other provinces have absolutely no legal support programs. And as my colleague from St. Albert, Edmonton said, one of our important recommendations was to ask the Federal Minister of Justice to work with her provincial counterparts to ensure that all provinces were able to provide post-trial support to jurors. We heard the quotes that were read by my honourable colleague from St. Albert, Edmonton. We heard compelling testimony before our committee that showed how deeply people were affected by their jury service. We heard people come out of the trial unable to take care of their children, unable to have relationships with their partner, unable to fend for themselves even in the world, and dropping out of the world and harboring themselves in seclusion. And that is not acceptable in Canada today, to stem from a compulsory service that we ask our citizens to be part of. So I would only hope that in addition to this very, very well-timed bill, that there is more that can be done through provincial, federal working together to improve the lives of jurors across Canada. Because the last thing we want is people to be disinclined to perform their jury service. Now, as to the bill that is put forward by my honourable colleague, this lies purely within federal jurisdiction. This is an issue that is in the criminal code. It is an issue where in Canada we have determined that it was inappropriate for jurors generally to discuss the matters that arose during deliberation, except if they were somehow raised in open court or they were the subject of a criminal proceeding. And that is not the case in every jurisdiction in the world. In the United States, for example, jurors are able to speak freely about their experience in deliberation, which has led to many books. All of us can remember the O.J. Simpson trial and how many books came out of the Simpson jury. Now, that is not the approach that our committee is proposing. We're not proposing, and nor did any of the jurors that came before us to speak to us at committee propose that jurors be allowed to enrich themselves by talking about juror deliberations in titillating or sensational trials. That is not the approach we're proposing. We took the time to listen to expert testimony from different jurisdictions in the United States, in Europe, and in Australia. And the model that we are proposing is the model that, as my honourable colleague mentioned, is used in the Australian state of Victoria. In the Australian state of Victoria, by the way, they actually have a coordinator for juries. They have a person whose entire job in that state is to be responsible for making sure that the juror experience in the state of Victoria is appropriate and that jurors are well taken care of. We in Canada would be well advised to find the ability at the provincial and territorial level to create the position of jury coordinator so that there is somebody that actually has the overall responsibility, not just for one trial, not just for one case, but overall to talk about the juror experience and make it better. We have bailiffs and judges and others who, with appropriate training, can do excellent jobs, but that doesn't mean that the experience should stop there. We heard testimony, Mr. Speaker, of jurors being confined to small rooms and small spaces. We heard testimony of jurors being told to park next to the accused or next to members of the accused family, of walking into court next to people who are testifying at trial. All of this could be avoided if we had someone who had an overall responsibility of walking through our courthouses, determining how best to allow jurors to have a decent experience. So in this case, Victoria, whose jury coordinator, by the way, came from Canada, told us that they had an exception to the secrecy rule that we have in Section 649 in our criminal code. They had an exception that when it came to speaking to mental health professionals, that jurors were allowed to do so, and it was exception to their general criminal principle that you couldn't talk about deliberations. And this is exactly what my colleague from St. Albert, Edmonton, is proposing in this piece of legislation. In our report, we recommended using Victoria as an example, and that's exactly what he's done. He's carved out a very small exception to allow those jurors who were deeply affected and could be deeply affected by the deliberations, which is, by the way, what we heard to be part of the most stressful part of juror service. You could have conflict with your fellow jurors in deliberation, Mr. Speaker. You could be hearing about gruesome, horrific testimony. You could, for example, be even in a point where you're at an altercation with fellow jurors because you're the only one that believes that the defendant should either be acquitted or found guilty. And coming out of your service, while you can talk about the other things that impacted you during the service to a mental health professional, in Canada, we do not allow that juror or someone providing support to that juror, for example, if the juror is hearing impaired, to talk to a mental health professional or other medical professional about their stress that they received in deliberations and to open up about deliberations, which could be the major source of their stress. So while it is well and good and excellent that we are pushing for provinces and territories to each have a mental health support program for former jurors, it still doesn't work as effectively if this exception is not created in the criminal code to also allow them to talk about their experience in deliberations. So my colleague from St. Albert, Edmonton, has taken a recommendation that was unanimously supported by all of the members of the committee. He's taken an example, a concrete example that exists in a different Commonwealth jurisdiction in Australia to show how it can be done. And he's put this into legislation, which I dearly hope that we can unanimously in this House support and move quickly toward the other place so that we can move forward down a path of helping jurors in an area of federal jurisdiction be able to be better treated when it comes to mental health services. Donc, je crois que ça, c'est une pièce de législation qui est très importante. Je salue mon collègue de St. Albert Edmonton pour son travail et tous les autres membres de la Commission sur la justice et les droits humains. Et j'espère très bien que ça pourrait être approuvé très, très vite. So, Mr. Speaker, thank you very much for giving me the opportunity to speak, and I appreciate the opportunity to speak in favor of this legislation. Let's get it through.
Before we go to resuming debate, I see the Honourable Government House Leader rising on a point of order.
Thank you, Mr. Speaker. There have been discussions amongst the parties, and if you seek it, I believe you'll find unanimous consent for the following motion, that notwithstanding any standing order or usual practice of the House, A, any recorded division requested in relation to the third reading stage of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts, or the third reading stage of Bill C-86, a second reading act to implement certain provisions of the budget tabled in Parliament on February 27, 2018, and other measures be deferred until Monday, December 3rd, 2018, at the ordinary hour of daily adjournment, and B, at the expiry of the time provided for oral questions on Thursday, November 29th, 2018, the House revert back to the rubric motions for the purpose of considering a motion to concur in the 66th report of the Standing Committee on Procedure and House Affairs. Thank you, Mr. Speaker.
La leader du gouvernement à la Chambre est-elle consentement unanime pour proposer cette motion? Oui. Oui. La Chambre a entendu l'énoncé de la motion. Plaît-il à la Chambre d'adopter cette motion? Oui. D'accord? Adopté. Resuming debate, the honourable member for Victoria.
Well, thank you very much. Thank you very much, Mr. Speaker. I had the honour to second on October 29th this bill, Bill C-417, introduced by my friend and colleague from St. Albert, Edmonton. As he indicated, we worked together along with the member who spoke earlier, the chair of our Justice Committee, the honourable member for Mount Royal, on the Justice and Human Rights Committee. And I enjoy working with him there, and I note that today he spoke with his typical eloquence to this bill. Mr. Speaker, I get many letters from my constituents urging me, when it serves Canadians, to work across party lines to do what Canadians ask us to, make laws that are going to make their lives better. If ever there was an example of that, it's tonight. I think I'm delighted to support this initiative. It's a nonpartisan issue. It's what I think you've heard the expression, Mr. Speaker, I would call a no-brainer. It's really hard for me to understand how people could resist such an obviously right thing to do. What does this bill do? Well, it makes it possible for you to seek mental health assistance if you have served on a jury and you're one of those very few people who are deeply affected by that experience, traumatized by that experience. Who could possibly oppose such a measure? Perhaps there's ways it could be improved by drafting, and of course that's the role of committees to delve into it further. But in principle, how can one possibly oppose this measure? I want to, along with my other colleagues, salute the work of my colleague from Cowichan, Malahat, Langford, who pushed us to do this and produced, as my friend from Niagara Falls pointed out, a bill that an initiative, a report that was unanimous and that everybody joined hands around. And I think that I commend him for doing so. It's a unanimous report. The member for Mount Royal has described some of the recommendations aside from this that are part of that report. But as he pointed out, many of them are in provincial jurisdiction. The beauty of this very simple and clean amendment to the bill is that it is entirely in federal jurisdiction. It's an amendment to Section 649 of the Criminal Code that very narrowly addresses the problem that he has described today. Mr. Speaker, I grew up in a place called St. Catharines, Ontario. I can tell you that community was traumatized by the Paul Bernardo and Carlos Hamalco trial. And to his eternal credit, Mr. Justice Patrick Lesage did something for which he had really no authority. He provided counseling for jurors who were affected by that horrific testimony, videotapes and so forth that changed people's lives, and I know that to be true because I know people who were affected by that horrible experience. And then we were at the committee, we heard other people, including Mark Ferrand, who both my colleagues have spoken of, who has become a leader in this initiative, stood with the honourable member for St. Albert Edmonton and myself at a press conference to tell his story. He's not afraid to tell the story of what happened to him by doing his civic duty. Now, both my colleagues have stressed that one of the few remaining things, if not the only remaining things, that Canadians can be compelled to do is do their duty on a jury. We depend on them. Our system of criminal justice depends on them. And that they put their lives once in a while in real jeopardy by doing what we require of them. But the thing that also needs to be said is in that criminal courtroom, the Crown Counsel will no doubt have access to effective medical assistance. The judge will as well, because they have that kind of support. Probably the defense lawyer would as well through the Canadian Bar Association insurance program or the like. People who choose to come in and sit in the courtroom do so voluntarily. But you know who doesn't have any support, Mr. Speaker? The juror. They get nothing, but they put themselves sometimes at great risk. And I'll give you some examples of the poignant testimony that we heard at Justice Committee to prove that point. That's wrong. And the state of Victoria figured it out, that it was the right thing to do, and they fixed it, and we should in Canada as well. So here's an example. One juror named Tina Denzer said, "What I had to watch, those girls being raped and tortured, wasn't just watching evidence. It was sitting in a box where I felt I couldn't do anything to save them. It was excruciating for me." And she goes on to say, "It's been over 22 years. I still have residual effects. If your 85-year-old grandmother is standing on the side of the road waving me down to help her with her broken-down car, I'm not stopping. I'm not stopping for anyone. I'm distrustful of most strangers. My family life is back to regular, but as a societal person, I'm highly distrustful of people." That's what jury service did to that Canadian citizen. Sonia Chopra, a former juror, said this, "I experienced nightmares, recurrent thoughts, loss of sleep, loss of balance, weight loss. Grinding of teeth at night escalated to clenching of teeth during the day, which led to headaches. I had a general feeling of anger all the time and the feeling of helplessness." I could go on, Mr. Speaker, but psychologist Vivian Lee said to our committee that because of stigma, jurors often don't recognize or seek help until much later in their lives, when their difficulties have impacted many aspects of their work and personal lives. The point of this bill, Mr. Speaker, is to say that it's okay to go to a health professional, seek counseling, and obviously take the steps necessary before, at a time when it's perhaps easier to make the changes that would make their lives better. According to the World Health Organization, every dollar we invest in mental health results in about $4 in savings to the Canadian and world community. I think that's applicable in this situation as well. So in conclusion, Mr. Speaker, I really want to commend the member for St. Albert Edmonton for his leadership. I want to say how proud I am to have served with the people who've spoken and others in this chamber tonight who are on the Justice Committee, effectively led, as I wish to confirm, by the member from Mount Royal. And I urge all members to support what the member for St. Albert properly called a common sense bill. Thank you.
Resuming debate, the honourable member for Niagara Falls.
Well, thank you, Mr. Speaker, and I want to begin by thanking my colleague, the member from St. Albert Edmonton, for introducing this bill and giving me, as well as so many of my other colleagues, the honour of seconding this bill. I remember the first time in Parliament back in 1984 when my colleague Pauline Browse asked would I second her motion to erect a statue to John Diefenbaker here on Parliament Hill. And I, needless to say, was very proud to have that honour, and I can tell you I'm very proud to have this honour, and I again thank my colleague for that. This is the first time that we have introduced legislation, Mr. Speaker, into this Parliament to address this critical oversight that you've heard about with respect to jurors in our justice system. And I appreciate the fact that my colleague from St. Albert Edmonton and all those who you have heard here are addressing this situation, which up till now has been basically ignored. I was Justice Minister for 6.5 years. I don't remember any reports, any memos or something with respect to the health and well-being of jurors. And so I am so pleased that we are taking steps, as my colleague, the member from Victoria, just pointed out, something that makes common sense. And so what we can get out of Bill C-217 is the protection that members of the jury need. And again, the member has proactively taken this issue that, again, has been ignored for too long. The legislation effectively speaks to, as you've heard, Section 649, which prohibits jurors from disclosing jury deliberations to anyone other than in relation to the obstructive of justice under 139(2) of the Criminal Code. This new legislation will allow jurors for the first time in Canada to seek the help of licensed practitioners such as psychiatrists and psychologists, and I'm so pleased to hear of the support. All the members of that when we were on that committee, Mr. Speaker, and you heard some of the testimony or some of the evidence, everybody is affected in some way or another. I see my colleague, the member from St. Catharines, who is here, and he still remembers, as we all do who lived in the Niagara Peninsula, the gruesome details of the Bernardo trial. I remember that trial, and I can tell you, indeed, my colleague from across there is correct when he said that the wounds from that trial have not healed. And all I can say, Mr. Speaker, is that thank God that man wasn't released on parole here just recently. As a matter of fact, there are people still suffering, still impacted by that trial. I heard from a constituent who was a friend of Christian French, and she reiterated the nightmares that trial live on in her family, friends, and jurors. And we heard, as you heard, Mr. Speaker, we had compelling testimony at the Justice Committee from Mr. Mark Ferrand and Mr. Patrick Fleming. Mr. Ferrand has been an advocate for jurors, and as you heard, he's one of those who has suffered PSD in addition to anxiety, depression, and nervous shock due to the distressing and disturbing evidence that was presented at the trial in which he served as a jury foreman. The 2014 trial that I was talking about was that of Farshad Badakhshan, who was convicted of second-degree murder in the death of his girlfriend, Karina Petrash. She was stabbed multiple times before her body was burned in a fire. Mr. Ferrand was subjected to viewing gruesome evidence over and over again. And it should be no surprise to anyone that jurors are traumatized by being obliged to sit and watch the graphic horrors repeatedly. In addition, Tina Denzer was another witness we heard from. She was the first one to be selected in the Bernardo trial, and she was the one who had to listen and see all the evidence with respect to the terrible evidence that was introduced at that trial. She wanted to close her eyes and look away, but she couldn't because she knew that it was her duty to watch the evidence. At one point during the trial, Judge Lesage had to call a recess on her behalf as she was having severe heart palpitations due to stress. She was referred to counseling. In his 29 years as judge, Justice Lesage had only ordered or recommended counseling for a juror on only 2 occasions, and the Bernardo trial was one of them. And, Mr. Speaker, it should be noted as well that he himself sought counseling after that trial ended. Ms. Deisner ended her testimony by saying that the counseling helped her manage the trauma and anxiety and get back to living her life. This speaks to the reason why C-417 is critical to protect our jurors. If we want to continue to have jurors to serve and to value their service, we need to ensure that they are provided avenues to reduce their stress, including the opportunity to talk about it and debrief afterwards. Many provinces do have juror support programs, such as providing free counseling to former jurors. This bill would increase the effectiveness of those sessions, as it would allow jurors to further discuss the reasons that why they have become significantly stressed. And many of our healthcare professionals who testified before the committee supported this change, as they felt it would improve the health of former jurors without compromising the sanctity of our jury system, which medical professionals are bound by the confidential requirements. So I thank all the members who have been involved with this, the member for Mount Royal, the member for Victoria, and of course the member for Cowichan, Matahal Langford, for encouraging and moving forward with this at the Justice Committee, because of that report, this is what you're seeing here today, this bill C-417. It's not without precedent, as you heard. There are other jurisdictions that are having a look at that. You've heard that in Australia, in the state of Victoria, they have had similar secrecy rules like Canada did, but their Juries Act of 2000 now allows jurors to discuss further deliberation, to discuss juror deliberation in the course of their mental health treatment undertaken as a result of their jury service. I have to tell you, as Justice Minister, Mr. Speaker, it was always very helpful to see what our colleagues in Australia did. They have many of the same issues that we have in Canada. Both countries adhere to the Westminster model of Parliament, and in fact are, again, similar in many ways. I always remember when the Prime Minister of Australia was here about 10 years ago addressing the Parliament. He said that, he mentioned that Canada and Australia were like identical twins separated at birth. And indeed, Mr. Speaker, having a look at what they do in other countries such as Australia, I think are very helpful for us here in Canada. One of the things, Mr. Speaker, I do want to touch on, and I was pleased that my colleague from Mount Royal raised it as well, is the lack of remuneration for members of the jury. To ask somebody to sit on a jury for 2 weeks and then not pay them, or be paying them $50 a day, contributes to the stress these individuals suffer from. And as my colleague pointed out, some provinces have not raised this since the 1970s. That's absolutely wrong. These people are an essential part of our justice system, and they shouldn't have that added stress of not being able to look after their home. Even employers who are stressed because they're losing their employees for perhaps long periods of time. So I'm hoping that that's one of the areas that in our discussions with our provincial counterparts say, look, time has moved on. Give these people the kind of financial support they need. But Mr. Speaker, this bill here represents the complete jurisdiction within Parliament that Parliament has, and I am so pleased and honored to be a part of this. And again, I thank all my colleagues here for all their wonderful support of this important bill. Thank you.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice.
Thank you very much, Mr. Speaker. I'm pleased to rise today to speak to Bill C-417, an act to amend the Criminal Code with respect to the disclosure of information by jurors, initiated by the member for St. Albert, Edmonton. As is readily apparent this evening, the bill proposes to amend the Criminal Code, Mr. Speaker, to provide that the prohibition against the disclosure of information relating to jury proceedings does not, in certain circumstances, apply in respect of disclosure by jurors to healthcare professionals. Our government indeed recognizes the crucial role and dedicated service of jurors in the Canadian justice system. As stated by a former juror, Mark Ferrand, who was quoted indeed by the moving member, the member for St. Albert, Edmonton, Mr. Ferrand said in his testimony before the Standing Committee on Justice and Human Rights that, quote, jurors are an important pillar of the justice system. And you've heard reference to Mr. Ferrand repeatedly this evening. Between November 22nd of last year and February 8th of this year, that Justice Committee undertook a study which culminated in their report, Improving Support for Jurors in Canada, which was rendered in May of this year. The committee has held 8 meetings in Ottawa to hear evidence from witnesses, including former jurors, Canadian and foreign government representatives who work directly with juries or in justice departments, Canadian and international lawyers, and other experts interested in the stresses that are associated with jury duty. Again, those committee deliberations and that committee report has been referred extensively in the speeches we've heard thus far tonight. So first of all, I want to indicate our thanks to the committee for their thorough study and their important report on this important issue. What I'd like to do now, Mr. Speaker, is take a moment to explain the jury process in Canada, because understanding the roles that jurors are asked to play is necessary to finding solutions to assist them with the difficulties that can result from their very important public service. In criminal cases, Section 11F of the Canadian Charter of Rights and Freedoms is triggered, and what that does is it grants any person charged with an offence the right to, quote, the right to the benefit of trial by jury where the maximum punishment for the offence is imprisonment for 5 years or a more severe punishment, end quote. And as provided in Section 471 of the Code, except where otherwise expressly provided by law, every accused who is charged with an indictable offence shall be tried by a court composed of a judge and jury, end quote. That's 471 of the Code, Mr. Speaker. So when a person is charged with a crime listed in Section 469 of the Code, the trial will automatically take place before a judge and jury unless the person charged with the offence and the Attorney General agree to a trial without a jury. In all of these types of criminal cases, Mr. Speaker, the jury is called upon to reach a unanimous verdict, determining whether the accused is guilty beyond a standard of what is called a reasonable doubt based on the evidence presented by the prosecution. In the context of civil cases, Mr. Speaker, the juries also have a role to play. While most civil cases are heard by judge alone, a defendant may also have the right to a trial by judge and jury, depending on the nature of the case and the court. Civil juries must decide on a different standard, the standard of a balance of probabilities, whether the plaintiff proved that the defendant violated the law in question. There are 6 jurors in a civil case, Mr. Speaker, and at least 5 of them are asked to agree upon a civil verdict. And finally, there's also an aspect of coroner's inquests that are triggered when we discuss jurors. Coroner's inquests aim to inform the public of the circumstances of a death, and those require jurors as well. Jurors must respond to questions about the circumstances of a death and may make non-binding recommendations. So unlike the civil or the criminal context, Mr. Speaker, jurors in the coroner's inquests are not required to render a verdict on anyone's legal responsibility. But serving as a juror in any of these capacities that I've just outlined can involve significant stress. We've heard a lot of testimony and a lot of submissions today in this chamber this evening about the stresses that jurors face. And those stresses have the potential to seriously affect a juror's life. What causes stress varies from one person to another, evidently, Mr. Speaker. Several examples were raised by witnesses at the committee, and I want to discuss some of these. For many Canadians, Mr. Speaker, being summoned for jury duty is the first and maybe the only experience that they have with the justice system. As a result, few prospective jurors are knowledgeable about what jury duty entails, and that unfamiliarity with the process itself often generates some anxiety. Many individuals feel therefore overwhelmed and stressed when they're summoned for jury duty itself. As expressed by Professor Jane Goodman-Delahunty, who said, quote, "Jurors are moving into an environment that is very unfamiliar to them. This can be very intimidating, and that alone can be somewhat stressful," end of the quote. Being exposed to disturbing information is also a fundamental aspect of what jurors are faced with. Again, we've heard extensively about this evening. It goes without saying, Mr. Speaker, that some legal proceedings deal with truly horrific and horrible crimes and involve traumatic and explicit evidence and testimony, which can include disturbing audio and disturbing video. This can be extremely stressful for jurors who are exposed to it. As Mark Ferrand explained, images would haunt me day after day. We've heard this quote earlier, but it bears repeating, Mr. Speaker. An unrelenting bombardment of horror. My daughter's red finger painting would hurtle me back to the scene of the crime, and I would stare transfixed, seemingly out of space and time. That was Mr. Ferrand before the committee that heard from jurors around the country. With respect to deliberations, Mr. Speaker, some jurors explained that they were uncomfortable with challenging group dynamics and the confrontations that sometimes occurred between jurors. So the deliberation process itself can be stress-inducing. Other individuals spoke about their significant fear of making the wrong decision or rendering a verdict that will have a life-altering impact, feeling the gravity of the task that was before them. A former juror, Michaela Swan, told the Standing Committee on Justice that for her, quote, "The most difficult process in serving as a juror was that of deliberations and the resulting post-trial discharge. It's confusing and highly complicated, but there is an immense drive to do the right thing." That's end quote. There's also an abruptness at the end of the trial, Mr. Speaker. Generally, after a verdict is rendered, the duty of jurors comes to an end. The committee heard repeatedly that for a number of jurors, particularly the ones serving on extensive and gruesome trials or inquests, the transition back to normal life is indeed challenging. Former juror Patrick Fleming explained, "We need assistance getting back to our normal life. We are civilians who do not choose this path for ourselves, nor are we trained to deal with this type of situation. Being a juror is a monumental job that has had a major impact on my life," end quote. Many of the former jurors who participated in the committee's study described the difficulties they experienced once the jury task concluded. Michaela Swan, who I mentioned earlier, stated, quote, "Within 20 minutes of delivering a verdict and after 4 days of being sequestered, I walked through an open parking lot with 11 other strangers and returned to normal life. I had Sunday to reconnect with my family, and on Monday I was back to work. As Patrick Fleming explained, quote, "At the end of the trial, it was so abrupt. 1 minute I was reading a guilty verdict to 5 individuals, putting them away for 25 years plus another 25, and then the very next minute, the court doors opened and I was going home. Think about that." Mr. Speaker, with respect to Section 649 of the Code, some jurors described feelings of isolation. Currently in Canada, jurors cannot discuss the case with anyone, as per Section 649 of the Code itself. They're cut off from their family and friends and their usual support networks with whom they would normally share troubling information and receive advice or encouragement. This also can be an added stress. As Patrick Fleming explained, I felt isolated from my family and friends. I would distance myself, and I could not share what I was going through. I felt guilty for not being present for my family emotionally and physically. In conclusion, Mr. Speaker, the important work undertaken by the committee clearly shows that it is possible to prevent or reduce the stress on the juror and with respect to their experience, particularly by improving the preparation process and the conditions under which jurors fulfill their duties throughout the legal proceedings, as well as by providing jurors with psychological support as needed. As was also mentioned earlier, it is a worthwhile investment. According to the WHO, every dollar invested in mental health results in about $4 worth of savings. It is important that we continue to work with provinces and territories to find solutions that support jurors and their mental health, including an examination of Section 649 of the Code. Thank you, Mr. Speaker.
Before we go to resuming debate and the honourable member for Oakville North Burlington, I'll just let her know there are only about just less than 5 minutes remaining in the time provided for private members' business, but I'll give her the usual signal and interrupt at the appropriate time. The honourable member for Oakville North Burlington.
Thank you, Mr. Speaker. And while my time might be short, I appreciate the opportunity to speak on this bill. And I want to start by thanking the member for St. Albert Edmonton for choosing this as an issue that he wanted to address through his private member's bill. It's one that's extremely important, and as he's heard tonight, and he knows himself, it's a nonpartisan issue. I am a member of the Public Safety Committee, and our first report that we did was also on PTSD and operational stress injuries, and it too was a unanimous report, just like the Justice Committee report, because mental health is something that crosses party lines, and it's something that we need to all be working together. And when people do put themselves in the service to the country, we need to make sure that we're looking after them. I was actually quite surprised, Mr. Speaker, that juries were not able to seek support from medical professionals when they were finished a trial. I first learned about it during our public safety study. And we had both nurses and jurors who reached out to my office to ask if our study could incorporate the mental injuries that they had suffered or that they had received. And of course, that was outside the scope of our study. We probably first became aware of mental injuries through our veterans. And certainly for me personally, that was the first time I started learning that people could receive mental injuries because of what they saw or what they heard. And so I think we've come a long way with our veterans. We're starting to make strides with our first responders and public safety officers. Certainly with both of those groups, we have a long way to go. But with jurors, it's something that just has not come up before. And I'm so happy to be able to be speaking to this, and that the Justice Committee took the time to study this issue in a broad sense with jurors. Much of it falls under provincial jurisdiction, where right now we have 4 provinces that are providing some kind of services to jurors, but really it's something that should be provided across the country. I quite liked the member from Mount Royal's suggestion that there should be someone who looks after jurors. Wouldn't that be a lovely way to support jurors in doing what they're doing? Certainly, from the testimony that you heard and that I read in your report, jurors, after they've been through a trial, your report mentioned they have intrusive thoughts, nightmares, trouble sleeping, development of phobias, anger, loss of appetite, sense of isolation, hypervigilance, depression, anxiety, and substance abuse problems. So, Mr. Speaker, I see that I only have 1 minute left. I think it's critically important that all parties support this bill. We have limited time left in seeing this get through the House and then hopefully get through the Senate to become law. So I'm very pleased to offer my support to the member, and I will be supporting this bill, and I will certainly be advocating within my own caucus to ensure that we get this important piece of legislation passed. Thank you, Mr. Speaker.